Hear me? Good. Good afternoon and welcome to the Jackson Center's, this is hard to believe, very last tea in ethics this whole semester. I don't know where the semester has gone, but I know that you know because you've had midterms and you're now getting ready for your finals, and all of us know that Thanksgiving vacation's coming up. So that's all good news. I want to welcome you here. My name is Claudia McCullough, and I am the director of the Jackson Family Center for Ethics and Values. I have a couple of little things to say today, and I don't want to take up time because our presenters have a fabulous program ready for you. So first thing I want to say, in case you haven't been here before, you may have heard the rumor, and it's true, I am really ugly about cell phones. Ooh, I am really ugly. So please turn your cell phone off. Do not please text during this presentation. And if you think that you're going to want to leave in before 5:30, I would ask you to go on and do that, because not only am I a real bear about cell phones, I'm a real bear about courtesy. And these two people have worked very hard for this presentation, and I expect the audience to stay at least an hour. Now, my promise to you is at 5:30, I'll call time. And if we aren't through with our questions, then those who want to ask some more questions can come down front, and then sometimes we get into the real meat of it. So I promise that at 5:30, time will be called. Now, second announcement is that on November the 2nd, the Jackson Center, it has as its very final date for applications for Jackson Scholars. If you are a freshman or a sophomore and you're interested in becoming a Jackson Scholar, I'm going to tell you this. Raise your hand, Amanda. This is Amanda. Amanda is my assistant director. She has packets in her hand for applications. If you would like to pick up a packet and look it over and just see if you're interested in it. We have Perry at the back door, and we have Sarah and Tara at the other door. They are Jackson Scholars. And if you would just like to say, listen, is that a good deal? And just have some private conversation with them, please feel free to. But we are very strict about our November the 2nd deadline. So if you're interested, come in. We're in 274 upstairs. Come into the center, chat with us, and let us tell you more about it. But Amanda does have some packets. House rule, when you run out of tea, please get up and get some more. That's why we have it here. There's plenty of tea, and I hope there are plenty of cookies. If they're not, tell us, because I've got some more stashed away. Okay? I look forward to today's program. Dr. Dylan Wittkower of the Department of Philosophy and Dr. Barbara Burd, who is the dean of our library here. And they have put together a wonderful program, so let's let them get started. Thank you.
Thank you very much. How many people knew what they were watching when they came in? Were you familiar with any of the music, the videos? Show of hands, anybody? Oh, okay. How many people listened to Girl Talk? That was one of them that you were listening to or watching. One of the things that we will be discussing today is whether the things that Girl Talk and other groups like them do, whether it is really legal to do that or whether it is ethical to do that. And I have been asked, just kind of to start out this talk a little bit, to talk a bit about copyright. As you know, I'm the dean of the library, and librarians exist because of some of the exceptions to copyright law. And so I'd like to talk to you a little bit about what copyright is and some of the exceptions to copyright. When we talk about intellectual property, basically we're talking about three kinds of property. It can be patents, it can be trademarks, or it can be copyright. And basically I'm going to focus my talk on just the copyright issues. The first thing that you should kind of be aware of with copyright is that there was an intent when copyright was written. And what I did prior to the constitutional copyright clause, copyright was in the hands of the states. Every state could determine what kind of copyright laws they had, but the constitutional copyright clause of 1789 says that Congress shall have the power to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. And some of the things that we need to look at there is what their intent was. So the purpose is to promote the progress of science and useful arts. And a little bit later, we'll talk a little bit, does copyright still do that? Does copyright still serve this purpose to promote the progress of science and useful arts? The other thing to notice here is that it's for securing for a limited time. When copyright law first came into effect, there was a very limited time period that there was a very short duration for copyright rights. And we'll see that over time, that duration has become longer and longer and longer. Now, copyright was put into the law to give rights to authors and inventors, recognizing that when somebody invented something or had an original work of scholarship or an original creation, that they deserved to reap the rewards of their work. And so that was the original intent for copyright. The Copyright Act of 1790 was the first act in the United States for copyright, and that act says it was an act for the encouragement of learning by securing the copies of maps, charts, and books to the authors and proprietors of such copies during the times therein mentioned. At that time, copyright was a duration of 14 years, but an author or an inventor had the right, if it was in writing, to extend the duration of copyright for another 14 years. The longest period of time that could be covered by anything under copyright was 28 years. And as we'll look at some of the further slides, what has happened recently to copyright and that duration, that limited period of time. The Copyright Act of 1976 is pretty much the law that we abide by now. There's been several amendments to that. We've had the Digital Millennium Copyright Act, we've had the Teach Act, but this law of 1976 is the law that codified and that defined much of the copyright that we abide by right now. So there are two elements for anything before it can be copyrighted. The first is that it has to be an original work of authorship, and the second is that it has to be fixed in a tangible medium of expression. Now, the law went on further, and it actually defined what are some of these original works of copyright. And it said any kind of literary works, musical works, dramatic works, pantomimes, choreographic works, pictorial, graphic, and sculptural works, motion pictures, and other audiovisual works, sound recordings, architectural works. As you can tell from that list, this is very dated. We don't do much with sound recordings right now. But there have been some changes. The Digital Millennium Copyright Act kind of brought this act up to include much of our digital works that we're doing now and to bring them under this copyright umbrella. Fixed in a tangible medium expression basically means that in a fixed time and space, you have to be able to view the work. So a lot of times, whether web pages are copyrighted has been argued, and it's been pretty consistent that the courts have said that all web pages are copyrighted. Now, what are some of the rights if you're a copyright owner? And we all want to be copyright owners because if we own copyright, it gives us certain rights and privileges. It also sometimes means that there's money attached to it, which is always a nice thing. So if you own something, if you're the author of something, it's nice to be rewarded monetarily as well as other ways for your work. Some of the rights of copyright owners. You have the work of reproduction. This means that you can say whether your work should be reproduced or whether it should be duplicated and by whom it can be duplicated or reproduced. The second right that you have as a copyright owner is the work of distribution. You have the right to say who should distribute your work. Whether you decide that you should sell it, lease it, rent it, that's up to you as the copyright owner to be able to say who has that right. And then the next right that you have is for derivative works. You have the right to say if anybody can take your work and form a new work out of your work. And what we're seeing a lot of times now with mashups and things like that, the question of whether it is a derivative work or not, or does it fall under fair use. The other thing, if you're an artist or a performer, you have the right to determine your public performance and display. It is up to you to say where your work should be displayed, how it should be displayed, and you hold all the rights to that. Now, as a copyright owner, you have the right also to assign those rights to somebody else. And you can assign all of the rights to somebody else, or you can assign partial rights to somebody else. But it is up to you. You have the right to do that. Originally, in the law of 1976, the Copyright Act, copyright term was extended. Remember I said before, it started out, we had 14 years with a possible additional 14 years. Well, the Copyright in the Act of 1976 extended the term of copyright to basically life plus the author. And that was in effect for quite a while, until 1998. And we had the Copyright Term Extension Act of 1998, and it's also known as the Sonny Bono Act. The Sonny Bono Act added 20 years to the duration of copyright, which means that basically now you're talking about the life of the author plus 70 years. And if it's a joint work, it's whatever author is the last living author. So now we've gone from a total period of 28 years to what could be a really, really long time. One of the things that we depended on as educators, scholars, and researchers, there has always been work that's gone into the public domain. That means when copyright ends at that period when the 28 years was over, or that life plus of the author plus 50 was over, the work went into the public domain, and so it was accessible to all of us. It was for the general good that work existed, and anybody could use that work. In the library, we had projects like Project Gutenberg that sought to digitize a lot of the classics in literature, philosophy, history, and that was because they could take works that were in the public domain and digitize them. Well, with the Copyright Act, Extension Act of 1998, that pretty much changed, and works going into the public domain stopped. And the next time that works will go into the public domain is not until 2019. So there was actually a huge, long moratorium now on works going into the public domain. So what are some of the limitations on copyright? A lot of the limitations on copyright have to do with the library, but the one that has to do with education the most, and what you're going to hear about most when you talk about the use of materials, is fair use. And fair use says that you can use materials without permission if it falls under, if there are certain elements that it falls under. And the elements that they talk about, there's 4 of them. Now, the thing with the copyright law, it doesn't say specifically, okay, if you do this and not do this, you're going to be safe. It kind of looks at it as a balancing act. And so with these 4 elements, the courts will balance and say, all right, is it more on one, does it weigh more on one side or on the other side? And the first thing that they look at is purpose and character of the work. So since we are in a nonprofit educational institution, that weighs very heavily in favor of fair use for copyright, or use of copyrighted works. The other thing, as faculty, if they post materials into Blackboard and it's password protected, that weighs very heavily towards fair use. The other thing, and you're going to hear this a lot when you talk about transformative works in mashup, is the idea of transformation. Is there so much change to this work that it actually took the work and created another original work? And so this is one of the things that if it is totally transformative, it weighs very favorably for fair use. The other thing that it looks at is the nature of the work. If the work is fact-based, if it's published, or if it's out of print, that weighs very heavily towards fair use. And then the amount of the work and the substantiality of the work. The amount of the work basically is if you are copying a very small portion of the work, and there's actually some guidelines like for educators and for education as far as how much is a guideline to copy. The other issue of that, and most of the time it ranges in the area of about 10% of a work that you can copy without having much fear of being in danger of copyright infringement. The other issue, though, is the substantiality of the work. And this is taking the core of the work, or the most important part of the work. And the recommendation is that you copy as little as possible from that core or value of the work, the most valuable part of the work, in order to weigh for fair use. The last thing that the courts will look at in determining fair use is the market effect. And that's basically if you are copying something, or if you are doing something and you're putting it into Blackboard, you're using it for course materials, what effect does this have on the market? So if you are, for instance, copying portions of a textbook and you're putting it into Blackboard, if by doing so you are diminishing the market value or making it so that more students don't buy that textbook, that's going to weigh against fair use. And so when it goes to the courts, they look at all those elements, and then they kind of weigh it out and say, this is what's for fair use, this is what's against fair use, and they'll come up with some kind of ruling. Fair use is the exception that we use whenever we post any kind of materials into Blackboard that are copyrighted. Some of the kind of interesting or somewhat interesting cases that have come up recently, and I don't know if anybody has read up or is that interested in copyright, to look at the J.D. Salinger case. Is anybody here familiar with it at all? J.D. Salinger was way before your time, but J.D. Salinger wrote Catcher in the Rye in 1951. He last published a book, and I believe it was 1965, but he has been an author that has been one of the most aggressive authors in maintaining his copyrights. And he has taken people to court over and over and over again where he has felt they've infringed upon his copyright. And most of the time it has to deal with Catcher in the Rye because it's considered an American classic. It made J.D. Salinger what he is. Well, J.D. Salinger is now 90 years old. And last year, I believe that it was a Swedish author who describes himself as a humorist, and he writes under the pen name of J.D. California, decided that he was going to write a parody of Catcher in the Rye. And his premise was what would happen if Holden Caulfield, who was your protagonist in Catcher in the Rye, was still alive, and what would Salinger's interaction be with him? And so J.D. Salinger was actually a character in this new book. He never referred to Holden Caulfield, but he called his main character H.C. And he used much of his language, his style of writing was very reflective of J.D. Salinger's work. He said that it was a parody of Salinger's work. Salinger took him to court, and I just need to read to you a minute what the judge said about this. Now, he was talking, his H.C. was 60 years old, his Salinger was 90 years old, and he tried to kind of construct these events where these two characters would actually come together. Well, the judge in the case said, and her last name was Bath, she said, in fact, it can be argued that the contrast between Holden's authentic but critical and rebellious nature and his tendency toward depressive alienation is one of the key themes of Catcher. That readers and critics have apparently idolized Caulfield for the former, despite, or perhaps because of the latter, does not change the fact that those elements were already apparent in Catcher. How do you think she ruled on the case? For or against? For Salinger. She ruled for Salinger, and she said that it was not actually a parody. And so this book is banned from publication in the United States. However, it is available elsewhere. And if you go to amazon.co.uk, it's there, and you can buy it. The other case that I just wanted to point out a little bit, some of the questions that come up with copyright. And most of us are familiar with this poster and with this photograph. How many people have ever heard of this case, AP versus Ferry? Okay, we have some familiarity with it. And with this case, the Associated Press claimed that this was the photograph that was taken by one of their photographers and that was then transformed into this poster that became then Senator Obama's campaign poster by an artist named Shepard Fairey. Fairey countersued AP and said that he had actually used another photograph, that this was not the photograph that was used, and they've probably been kind of in and out of court and in and out of settlement discussions for the past year or so. But last week, Shepard Fairey came out and admitted that this was the photograph that he used to transform into his poster. In the past, he had said that it was a photograph that was taken of President Obama and George Clooney, and that he had to do a lot more photoshopping and manipulation of the photo to make this poster. As he admitted that this was the actual photo, his legal team, many of them withdrew from the case, but AP is continuing their suit against him. Now, Fairey, though, probably has a very strong case because he's still claiming that this is fair use. And you will have to decide yourself, is the poster transformative and would fall under fair use, or is it not transformative and was it used without their permission? If it was used without their permission, Fairey has made a lot of money on this poster. And of course, in AP's lawsuit, they would like some of that money that has been made from the poster. If it's fair use, then AP has no claims to any of the rights for that poster. So it'll be interesting to see what happens in the future and how that's decided. Though most people are saying that Fairey really did himself a disservice because he admitted that what he had said originally was fraudulent. Another thing that I've just been asked to talk about briefly, because there's always a lot of confusion between what is plagiarism and what is copyright. Copyright is governed by law, and plagiarism isn't. Plagiarism is an educational, scholarly research construct or element, and it's governed by the educational institution itself. Copyright infringement is using another person's work without permission. Plagiarism is using another person's work and failing to give proper attribution through citations. If you plagiarize, there's really no legal consequences to plagiarizing. If you are infringe on copyright, there is, but your consequences in the educational institution could be quite severe for plagiarism, as you know, that Coastal Carolina has basically a no tolerance policy for plagiarism. So there is a very distinct difference between plagiarism and copyright, in that the one is covered by the law, but the other one is covered by the educational institutions themselves. An additional resource that I would just like to mention, and for anybody who is using any kind of copyrighted materials in teaching, or as a student, if you're looking at using copyrighted materials in programs or reports or anything like that, there's an excellent resource called knowyourcopyrights.org that pretty much tells you what you can use and how you can use it. And so now I'm going to turn you over to the fun part of the program to talk a little bit about some mashups and mixes and the ethical considerations of using those. Thank you.
Well, I'm not quite sure that this is going to be the fun part exactly. It's certainly not going to be the colorful part, at least. After this good introduction to what copyright law is, what it covers, and controversies within it, what I want to talk about is the ethical basis of copyright law. Now, is this large enough that you all can read it? Should I? No? Okay. Is that better? Yeah, a little bit better. Let me see if I just worried this. Well, let's go with that. Okay. The explicit basis of U.S. copyright law is a utilitarian foundation. Whoops, that's the wrong thing. All right, sorry. Where, I mean, as we saw there back in the second, oh, no, there it is, back in the second slide, there it is. All right, sorry. That the point here is to promote the progress of science. So there's a right to the author, but the overall intent is the social good. And that's the way in which copyright is, in U.S. law, intended to have a utilitarian foundation. Now, nevertheless, when we look at the kinds of beliefs we have about copyright and the kinds of ways that we think we owe it to authors, we don't just think about this in utilitarian terms, but we tend to also use Kantian and Lockean foundations. And these intuitions they're intuitions that'll be familiar to you, even if you haven't ever read Locke or Kant. So I'll go through each of these pretty quickly. I'm not sure how much of this I'm going to get through in the next 20 minutes, but no matter what, I'm going to stop after 20 minutes so that we have time to do some questions. So hopefully I'll at least get through these, if not to some of the objections. But all right. The basic idea with Lockean labor desert theory is that nobody has any inherent right of ownership of anything. And Locke was, when he was writing this, he was writing the context of the divine right of kings. This is a good while ago, where he was saying it doesn't make sense to have ownership of property be based on the descent of royalty, but instead that we should all own the world in common, unless there's some particular reason why some of us gain a right of exclusion, gain the right to tell others, I own this, and and you don't, and you can't use it or make use of it. Locke is really talking about physical property here, and I'll say something about how this applies to intellectual property in just a moment. But his basic idea is nobody has any inherent right of ownership over the world, but instead we acquire rights through our labor. That by working on elements of the world, by improving it, we mix our labor with it. And since we own our bodies, We own that which we pour our lives into, that which we mix our lives with. So when I go out and I gather fruit in the forest, I didn't make that fruit. The trees made the fruit, but I nevertheless gain an ownership right over it because I'm the one who put in the labor to go and collect it, to bring it to market, and so on. And that's what makes it appropriate, according to Locke, that I should call that fruit mine and that I should be able to sell it. So, and that's the basic idea. As long as we leave enough so that other people can improve the world and gain property in it too, we're right to claim ownership over that which we've worked on, labored on, and invested our blood, sweat, and tears, and so on. So with intellectual property, we often try to apply this intuition, and it really doesn't fit very well. And the courts recognize this. There are numerous different legal cases that I could cite here. This is one of them, but in U.S. law, we've recognized that sweat of the brow, that just labor alone, does not generate copyright. And we saw this in the way that copyright was discussed before. The legal terms are, it applies to creative work and it applies to expressions. So in cases like this, where one company took somebody else's phone book and basically copied it and sold it, the courts have ruled, well, that's public information, it's not creative work. You can't have a copyright in that. So if other people decide to do that, they can do that. Now, those are the legal terms. Morally, things get a little bit more complicated, but still, even according to Locke, his theory does not apply to intellectual property. Locke actually talked about this. He had a utilitarian view of intellectual property. But basically, one way that we can look at this is if you've labored on something, you own it. That's perfectly fair. But if you've labored on something and you own it and somebody else copies it, well, you still own it. You write a song. You still have that song. Somebody else sings that song. When doing so, they haven't taken anything away from you at all. You still have that song. It's still yours. So on a Lockean basis, it's not clear why we would disallow other people from reworking the material that we've already worked, or even simply just copying it and distributing it. So this Lockean idea, it's one of our strong intuitions about intellectual property rights, but it doesn't seem to justify a right of exclusion. Locke, the way that he formulated this to protect us and to protect our freedoms from government, in particular from royalty. And Locke, he wanted to ensure that we all had the freedom to do whatever we want, to create things and to enrich our own lives. So it seems like Locke wouldn't really agree with the whole idea of copyright. Now, that's one of our intuitions. Another one is a Kantian personality theory. And this is rather different. Kant's view of intellectual property is the foundation of especially German copyright law, but to some extent also French copyright law, where the basic idea is founded not on a utilitarian basis, not on the idea that this is better for society, nor on a Lockean basis, where we say that the author just simply has a natural right to property. But instead, Kant says copyright it's just something made up. It's a legal fiction. But it's an important one because there's great importance in allowing authors to speak to their public. And the purpose of copyright, according to Kant, this is from a little-known essay of his called On the Unauthorized Publication of Books, an essay he actually wrote specifically about copyright. He says, we need printers to publish stuff. Otherwise, authors can't communicate with publics. And it's at the core of our Enlightenment ideals. It's at the core of our ideals of learning and sharing and communicating and being able to bring our culture forward in knowledge and innovation, that we be able to communicate with each other. So he says basically, in order to realize this important goal, we need to give publishers exclusive rights to copy, exclusive rights to print, publish, and sell particular expressive works. Otherwise, they just won't do it. If we don't give them, they're motivated by profit, it's expensive to print stuff, we need to give them an exclusive right. And the way that he talks about this and the way that it's included in American law is it's a kind of artificial monopoly, where we say nobody's allowed to sell a competing good. Nobody's allowed to sell the same book, a directly competing good. And it's an artificial monopoly for Kant that is meant just to ensure that publishers have an interest in allowing authors to speak to their publics. Now, today, things are different. We don't need publishers. We can publish our stuff online. So for Kant, this Kantian view, this supports moral claims against plagiarists, anybody who claims to be speaking for themselves when they're actually using somebody else's words. That goes against our moral rights as authors to be able to communicate with publics, and our moral rights to be able to speak in our own voice. But that's it. We don't need publishers. We can publish ourselves, and even scholarly publications. Journals are increasingly open access, where they're just published online. You can get a print copy if you want, but you can just go online and get there. And of course, that fits with our goals in publication. When we publish, we want to reach as many people as possible. The only real exception to this is when we're trying to sell something, to publish something in order just to make money, rather than to publish in order to reach people. But of course, that only makes sense that you should be able to publish in order to make money if we can figure out why it's fair for you to sell something that somebody else can just copy. In other words, with digital media, a great deal of the foundation of copyright changes. We can publish ourselves, and we don't need to ensure that somebody's paying for it, because with digital media, I can just hit copy and paste. I don't have to transcribe something and put together plates and reprint it. Or even with, it's not even like it used to be with electronic tapes and music. We don't have to dub things. It's done immediately and with very, very little cost, minuscule cost. And Kant, it's this absolutely bizarre footnote in this little-known work of his. He actually specifically says something that, in today's context, supports remixing and supports sampling and mashups, like we saw before. He says there, and it also fits with the transformative aspect of fair use. He says, if someone so alters another's book by abridging, adding to it, or revising it, that it would be wrong to pass it off in the name of the author of the original, then this is not impermissible. This is not unauthorized publication. The reason being, for Kant, what's wrong about copyright infringement is that it hurts the interest of the author in communicating with her public. But here, if I take somebody else's expression and change it to make it into my own expression, that doesn't change anything. So, and Kant really kind of ridiculed this really strange footnote. Well, the third of these, as I said, this is the utilitarian justification, is the one that in fact underlies our current law. The basic idea here is that we grant a temporary monopoly in order to encourage production. Again, this is to promote progress of science and the useful arts. So we secure then for limited times the exclusive right, the monopoly in the market to sell this work. So here, again, like with Kant, there's no claim that there's a natural right or a moral right to be able to exclude others from using it. It's a utilitarian justification that just says it's better for everyone if we pretend that there's this right. So, and the reason why it's better for everyone is that this way we encourage science and the useful arts. If we have more people who can support themselves by creating creative works, then presumably we're going to end up with more creative works. If we have more people who can sell their inventions, we're going to end up with more inventions. And that value goes back to society after the expiration of the copyright term. Think of this from our Constitution, the limit of 14 years renewable. After 14 years, the idea was there would still be significant value in that work. So people would be able to use it, to play with it, and to learn from it and reproduce it freely, in the way that we do today with various things that have fallen out of copyright. This is one recent example that's particularly bizarre. I don't know, I haven't checked it out, but I'm kind of happy about the whole thing. They just put out this one too. But anyway, I mean, Jane Austen is in the public domain. Jane Austen is out of copyright, so we can do stuff like this. We can play around with Jane Austen. We can make movie adaptations. We can rewrite her words. We can create audiobooks of her words. And we can sell it or give it away or whatever. So the idea is that there's this copyright bargain where the public loses these rights to reproduce, to share, to remix, and to redistribute, but only for a little while. And then after 14 years, we'll be able to do whatever we want with that stuff, unless it's really valuable, and then the copyright owner might renew it, but still, 28 years. Now that we're up to life of the author plus 70 or 95 years, this changes significantly. Most works are of little value by the time they fall out of copyright today. Most of the things that will enter the public domain starting in 2019 are things that aren't really relevant anymore. Most of the things that are covered by copyright now are out of print because it's just not worth it to keep printing them. And yet, we are prevented from using any of that stuff in the meantime. This becomes especially troubling given that we now have the means of mass communication, given that we now have the means to copy, paste books, and to take old music, to remix it, to recreate things with it, and to republish it, to transform these works. So with digital media, what we are losing in the copyright bargain, our public rights that we've lost in the copyright bargain, have become much more important. We're losing more and more because we have much more ability to make use of intellectual property with digital media than we used to. And at the same time, copyright term has been extended so far that most of the work, by the time we get our hands on it, isn't really worth that much anymore. So the only real justification morally of this today is, on a utilitarian basis, is that if the goods that we get through profit-motivated production, through production that's motivated by this exclusive temporary monopoly that we grant, if those works are so much better than what we would have otherwise, that it's worth it, that it's worth having all of these goods, even though we don't have any rights over them, even though we can be sued for $15,000 if we share one song, which is the current cap. And I don't feel this is true. I don't feel this is true at all. Most of the stuff that's produced under copyright is pretty worthless. And even with it available, even with it increasingly available, we keep turning to work that isn't produced out of profit motive anyway. We keep turning to online content that's shared for free. It's often created by users who create it not because they want to make money, but because they want to express themselves, because they want to publish, because they want to reach an audience. And frankly, I'm more inclined to think that music, for example, is going to be better when the author is creating it because she cares about the music than when she's creating it because she's trying to make money. And if you followed any of the stuff with artists struggling against record labels, Artists, of course, end up giving their copyrights away to record labels in order to get signed. Record labels don't seem to be terribly good for the music either. And a lot of musicians, like Amanda Palmer recently has been posting about this on her blog. Sorry, there it is, where she talks about how, here, I can't highlight it because you won't be able to read it, but she says here, for the last 10 years, I've been working my ass off in a different way, tirelessly making music, traveling the world, connecting with people. I'm sorry, I forgot to mention, Amanda Palmer is the lead singer of the Dresden Dolls, and you might be more likely to know her under the band's name. She says, almost never taking a break, and frankly not making a fortune doing it. She says, I still struggle to pay my rent sometimes. I'm still more or less in debt from my last record. And she says, I'll lay this all out for you some other time. So this doesn't produce the most valuable work that we could be getting anyway. So the copyright bargain has become an increasingly bad deal for the public because the rights that we, members of the public, have to give up have become much greater as we have more control and more ability to produce art ourselves and to remix and to share, to distribute, and to create. There's much more about that. I'll address at least one objection quickly, and then well, maybe we should just go ahead and switch to questions, since we have just 10 minutes left here. I would guess that some of these objections might be questions anyway. So,
any questions to Dr. Wittkower or Dr. Burd? I have one.
Yeah.
Could you move me one more time from plagiarism to copyright law? I am a little confused about that.
Basically, copyright is law, and it's covered in the U.S. Code. Title 17 of the U.S. Code covers copyright law. Plagiarism is mentioned in law. It's educational research scholarship.
But suppose I plagiarize and then go out and sell it and make a profit. Am I now in a copyright ring?
If you've taken something without permission, yes, then you're going to turn it into copyright infringement.
All right, so it's the profit motive that does that. I'm familiar with a case like that in another institution, so I was kind of blurry on the difference.
Does that material have to be copyrighted first before it becomes a violation of copyright law?
No, actually, anything that is in a fixed medium of expression is copyrighted, whether you register it with the Copyright Office or not. Once you fix something, an original work of authorship in a medium of expression, it becomes copyrightable. Now, you can add copyright symbols to it as I would say maybe a protection. And if you register with the Copyright Office, if there is any kind of questions that it goes to the court about copyright infringement, it does give you a little more of a protection if it's registered. But actually, anything that you do that's an original work of authorship and it's fixed is already copyrighted.
You have to prove that, correct? Like, say you come up with a...
You have to speak louder, so
Say you pick a song or something of that nature, but you don't register the Copyright Office, and you don't go to ask that for something and get it restricted, and then someone else finds that song on the internet, uses it, publishes it, or records it, and makes money off it, and people would try to argue that you came up originally, you never registered it, you hold no weight.
And that's where you get additional protections if it's registered, because then you don't have the argument about who is the author of it.
What did you say was the medium of expression again?
Well,
can you repeat the question because they can't necessarily hear it. Thank you.
Like, what exactly is a medium of expression?
Okay.
well, a medium of expression it's going to depend on what kind of work it is. So for an author, it's a written publication. It could be a book. For an artist, For a choreographer, it's a dance routine. So anything that can be fixed in a medium, that's exactly what it is. It's a medium of expression. So any way that an artist or an author you can visualize that person's work, that's a medium of expression.
I've heard, it wasn't covered here, so maybe what I heard was false, but that if a song, for example, was created more than 50 years prior, that it becomes part of the public domain. For example, you started hearing the Andy Griffith song on commercials. Older songs, you start to hear more on commercials. Is that false? Or did this 20-year thing, does that go, well, I'll change that? Or?
It did change it, and I'll use an example. Happy birthday. Happy birthday is still on your copyright. Don't sing it in public.
Can I tell you a quick story to back up what you said? We used to live on Hilton Head Island, and there was a man there who was fabulously wealthy, as many are, really wealthy, and he wrote Popeye the Sailor Man. And that's the only thing he ever wrote his whole life, and every time it's played, he gets a royalty. That's all he ever did in his life. Sure. He said from his big old yacht.
Apparently, the Happy Birthday is under copyright till 2030. There was a woman who wrote this as "Good morning to you, good morning to you, good morning, dear students, good morning to you" in a education book, and then there was a Broadway musical some years later. I think probably 25 years later. It was a good number of years later that had the Happy Birthday song, and her sisters, she was dead by then, sued the Broadway people because they said it was the same song, the lyrics changed. They won, and currently the copyright is held 50% by the descendants of the sister of the woman who wrote a different song substantially similar to Happy Birthday to You, and the other half is owned by AOL Time Warner. So this is why chain restaurants don't sing it, because they're big enough to be worth suing.
Dylan, I wondered, recently, in the last, 8 years, Creative Commons become sort of one of these grassroots ways of being able to share things and yet still retain a certain amount of copyright. And it's something that seems to sort of span the gap between some of these other approaches.
Yeah.
And you can sort of decide as the content creator what level of Creative Commons you want this to come in on. So I produce something and put it on the web and say, okay, I want it to be available to people, but you need to make sure that you credit me when you use it. And that's sort of from an ethical point of view, that's sort of a nice way of being able to say, yeah, that's perfectly fine. I'm not trying to make money on this, but I want people to know that at least that I'm the one who first came up with it.
And you can also specify no derivative works if it's something that you don't want to see somebody remix in a way that's going to make you uncomfortable.
Right.
This is a very good way of trying to follow some of these goals, as you were saying, it's sort of middle path, where if you want to just communicate with the public, so you want people to share, you want people to reproduce your work and to repost it. You can allow that while at the same time keeping artistic control over the work by saying you can't remix it. And a lot of people use this on Flickr, especially. It's very common usage on Flickr to share work in that way. It's great that Larry Lessig has been working on this, and I encourage those of you who are creators to check out Creative Commons. It might be a good way for you to manage things without having to assert full copyright, while allowing other people to make use of your work too.
I hate to say this. Sarah, you have a quick question?
It's a longer question.
I have my 30. You don't have my 30?
I mean, what I'm arguing here is that what Locke and Kant claimed was that the most extensive form of copyright that we should allow would be something like Creative Commons. I mean, Kant says anyone should be allowed to remix. Of course, he's talking about books, and he's not talking about music or movies or anything else. But I mean, that's pretty significant just for books, really changing somebody's expression and being able to say, this is now my work. And Locke similarly said, we don't have any real right over intellectual property. He said, I wrote this, somebody else should be able to write something based on it. And the only reason he thought copyright was a good thing was basically for the same reason Kant did, that you need it to get publishers to publish stuff. And we don't need that anymore.
Before we leave, those of you who have to go, I hope all of you won't, we can ask a lot more questions. They volunteered to stay for a little while longer. A couple of reminders. One is Amanda standing in the back. If you want to inquire or pick up a little booklet and an application for become a Jackson Scholar. The second reminder is there are cookies left in the pocket. They don't please. Because if you don't